In this video, I want us to shift our attention to public policy and illegality, and we are going to look at these two also in relation to void contracts. Now, let's first of all define public policy and illegality. You see, public policy refers to legal principles designed to protect society's interest and maintain public welfare. And an illegal contract is a contract the court will not enforce because its purpose is unlawful or contrary to public good. So the key legal principle to remember is that a valid contract must have a lawful object. If, for example, you agree to pay someone 50,000 Kenyan shillings to ban or destroy the shop of your competitor, then that kind of agreement is legally illegal. In fact, a court cannot enforce that kind of agreement. Now, let's look at the types of illegal contracts. You see, a contract may be illegal by a number of ways. The first way a contract may be illegal is by statute. And this is where Parliament expressly, prohibits that particular contract. And a good example is under the Employment Act of Kenya, wages and salaries must be paid in terms of money. So that a contract to pay salaries using goats or using chickens or using a sack of maize is considered illegal. If a farm owner in the village agrees to pay workers using potatoes instead of wages, then that arrangement is considered unlawful. The second way a contract may be illegal is by common law. And here we are talking about court-made kind of illegality. You see, courts can declare contracts illegal if they offend public policy. Now, remember I have said that public policy refers to legal principles designed to protect, society's interest and also maintain public welfare. The third way a contract may be illegal is contracts to commit crime, tort, or fraud. So that contracts to commit crime, tort, or frauds are automatically considered illegal. Examples include, contracts to steal, contracts to assault, and also contracts, to forge documents. If you look at the case of Bigos versus Posted, the facts of this particular case were that the parties entered into a contract meant to violate, exchange control regulations. And the issue was whether the contract was enforceable. And the rule is that a contract intended to break the law is considered illegal. And the application of this particular case was that the court found the purpose of the contract to be unlawful, therefore the contract was unenforceable. So that paying someone to fake your academic certificates is actually considered illegal and unlawful. The fourth way a contract may be illegal is contracts, prejudicial to public safety. So that contracts prejudicial to public safety, threaten national security. Examples include, funding rebels, assisting terrorists, and also helping enemies during war. Now, the legal rule is that public safety overrides private agreements, so that giving money to armed criminals to overthrow the government is actually considered illegal. The fifth way a contract may be illegal is contracts prejudicial to administration of justice. You see, contracts prejudicial to administration of justice interfere with justice. So that contracts prejudicial to administration of justice, include a number of things. They include, stifling prosecution, and that is agreeing not to report a crime because you've been given money. And a good example is when a thief pays the victim not to report him. This is considered illegal and unlawful. Now, contracts prejudicial to administration of justice also include number two, charity. And this refers to funding someone's case in order to share, the court award. And a good example is, a friend funding your land case, expecting, 50% of the damages. This is potentially illegal and unlawful. Contracts judicial to administration of justice also include number three, frivolous, kind of litigation. And this refers, to funding, weak cases in order to harass others. And a good example is paying someone to sue your enemy just to stress your enemy. You see, this is considered illegal and unlawful. The sixth way a contract may be illegal is contracts to defraud state revenue, so that tax evasion contracts are considered illegal. If you look at the case of Miller versus Kalinsky, the facts of this particular case were that an employer and employee agreed tax deductions will be refunded. And the issue was, could employee recover the refund? And the rule is that, tax evasion, agreements are considered illegal and unlawful. And the application of this particular case was that the arrangement, denied, government taxes. And so the conclusion of this case was that the recovery was denied. In fact, if an employer pays, part salary secretly, in order to avoid, pay as you earn, it actually amounts to an illegality. The seventh way a contract may be illegal is contracts promoting corruption. You see, corruption undermines public trust. If you look at the case of Parkinson versus College of Ambulance, the facts of this particular case were that the plaintiff paid money hoping to get a knighthood. And the issue was, could the money be recovered? And the rule is that contracts promoting corruptions are considered illegal. And the application of this particular case was that the donation was meant to improperly influence owners. And the conclusion of this particular case was that the money was irrecoverable. So that paying someone to secure government tenders unfairly amounts to an illegality. The eighth way a contract may be illegal is contracts, promoting sexual immorality. So that contracts promoting sexual immorality are contrary, to morals. That is contra bonus mors. If you look at the case of Pierce versus Brooke, the facts of this particular case was that a carriage owner hired his carriage to a prostitute knowing its exact purpose. And the issue was, could he recover payment? And the rule is that contracts promoting immorality are considered unenforceable. And the application of this particular case was that he knowingly assisted, the promotion of prostitution. So the conclusion of this particular case was that the recovery was denied. So that renting a house knowing it will be used as a brothel amounts to an illegality. The ninth way a contract may be illegal is contracts based on illegal contracts, in that a contract founded on illegality is also considered illegal. Now, the rule is that you cannot build legality on illegality. So that if you borrow money to bribe an official and then ask your friend to guarantee repayment, then that guarantee is definitely tainted and it is illegal. Now, what are some of the effects of illegality? You see, an illegal contract, creates no rights, it creates no obligations, and cannot be enforced. Now, the rule is that the court leaves parties exactly where it finds them. Be that as it may, there are actually recovery exceptions. So that recovery is allowed where, number one, there is repentance before performance. And this is a situation where a party withdraws from the contract very early. So that if you pay a bribe, but change your mind before the bribe is used, then recovery can actually be possible. Recovery is also allowed where there is not equally guilty. That is not in pario delicto, in that the less guilty party may actually recover. so that if a minor is tricked into an illegal transaction, then the minor may actually recover. Recovery is also allowed where there is independent ownership, and this is where property is recovered without relying on illegal contracts, so that you can recover your car even if it was used in an illegal kind of deal. Now, I want us to shift our attention very fast to void contracts. You see, void contracts are contracts which are treated as if they never existed. Now, the difference is illegal means unlawful purpose, but void means lawful purpose but unenforceable. Now, let's look at void contracts at common law. Now, the first void contract at common law is contract hosting court jurisdiction, in that an agreement cannot completely remove the access of courts. But there are exceptions like ADR clauses on arbitration and also mediation. So that a contract saying you can never sue me in court is considered void. That is, it is invalid from the beginning. It is a nullity from the beginning. Now, the second void contract at common law is contracts prejudicial to marriage. You see, contracts prejudicial to marriage actually interfere with marriage. And a good example is paying someone, to arrange a marriage or encouraging, divorce. So that paying someone to separate a married couple is considered void. It is invalid from the beginning. It is considered a nullity. The third void contract at common law is contracts in restraint of trade. You see, contracts in restraint of trade restrict freedom to work or freedom to do business. And an example include, where an employee is barred from joining competitors, and when a seller is barred from opening a similar business. So that at common law, these contracts are considered void. However, they can be enforceable if they are reasonable, if they are necessary, and if they are not against public interest. Now, let's look at voluntary restraints. You see, the first voluntary restraint is employee restraints. And this is when an employee agrees not to compete. If you look at the case of Partsman versus Taylor, the facts of this particular case were that an employee agreed not to work in 3 Birmingham areas for 3 years. And the issue was the restraint valid? And the rule is that reasonable restraints are enforceable. And the application of this particular case was that the area and time were actually reasonable. So that the conclusion of this particular case was that the injunction was granted by the court. Now, if a barber agrees not to open a barber shop next door to his former boss for about 2 years, then that contract is reasonable and can be enforced by the court. If you look at the case of Atwood versus Lamont, the facts of this particular case were that an employee was restricted within 10 miles. And so he ended up opening a similar business beyond 10 miles. And the issue was whether the restraint was enforceable. And the rule is that overboard restraints are considered void. So that the application of this particular case was that the restriction was actually too wide, and so it was considered to be unenforceable. Now, if a chef is banned from cooking anywhere within Nairobi, then that is too broad and cannot be enforced by the court. If you look at the case of Nordenfeld versus Maxim, the facts of this particular case were that a seller agreed not to make guns worldwide for about 25 years. And the issue was whether worldwide restriction is valid. And the rule is that wide restraints may be valid if necessary. And the application of this particular case was that gun restriction is reasonable due to the uniqueness of that kind of business. So that the conclusion of this particular case was that the contract was partly enforceable. So that if you sell Coca-Cola formula, for example, and agree not to make a similar soda globally, then that is reasonable and can be enforced by the court. If you look at the case of Coros Manufacturing Company versus Corlock Manufacturing Company, the facts of this particular case were that companies agreed not to employ each other's former workers. And the issue was whether the agreement was enforceable. And the rule is that reasonable business protections are actually allowed in law. And the application of this particular case was that the restraint, protected commercial interest. And the conclusion of this particular case is that the contract was enforced. Now, the second voluntary restraint is vendor restraint. And here, a seller agrees not to compete, after selling business. Now, the purpose of this agreement is to protect goodwill. If you look at the case of Dias versus Souto, the facts of this particular case were that a seller sold business in Zanzibar and promised not to compete. But this seller later opened, a similar business. And the issue was, could buyer restrain, the seller? And the rule is that reasonable seller restraints are enforceable. And the application of this particular case was that that kind of business was actually specialized. And the conclusion was that the court actually enforced that particular contract. So that if you sell your pharmacy, then open another pharmacy next door, then the person who bought the pharmacy from you can actually sue. The third voluntary restraint is solace agreements. Now, solace agreements refer to exclusive dealing arrangements. Now, types of solace agreements include number one, tying covenant. And this is a situation where you buy only from one supplier. And a good example is a petrol station buying fuel only from one oil company. The second type of solace agreement is compulsory trading covenant, and this is a situation where you keep business open during set hours. And a good example is a supermarket must operate between 8 a.m. to 8 p.m. The third type of solace agreement is continuity covenant, and this is a situation where future buyers must continue with the same restrictions. And an example is selling, a franchise with the same obligations. Now, let's look at involuntary restraints. Now, involuntary restraints are restrictions imposed by professional bodies, like, the rules by the Law Society of Kenya, CPD points, and professional indemnity. Now, these are valid if they are reasonable, so that advocates must follow professional rules to continue practicing law in Kenya. So, what is the Kenyan position on restraint of trade? Governed by the Contracts in Restraint of Trade Act in Kenya, Section 2, restraint clauses are valid unless unreasonable, so that courts considers, the nature of business, the duration, the geographical area, circumstances, and also public interest. If you look at the case of Steel Structures Limited versus David Engineering Limited, the facts of this particular case was that a former employee joined a rival and the employer sued very late. And the issue was, could courts enforce restraint? And the rule is that courts may refuse if events have overtaken the matter. And the application of this particular case was that the employee had already worked for several months. So that the conclusion of this case is that the court refused to enforce that particular contract. So that trying to stop a worker after he has already settled in a new job is considered legally to be too late. If you look at the case of Craft Silicon Limited versus Voi, the facts of this particular case were that former employee contacted, old customers. And the issue was, could restraint clause apply? And the rule is that reasonable clauses are enforceable. And the application of this particular case was that customer restriction was okay, so that employment restriction were found to be too vague. The conclusion of this particular case was that it was partly enforced, so that a former Safaricom sales agent can work elsewhere, but cannot poach Safaricom customers unfairly. Now, here is a quick summary of what we've covered so far. For illegal contract, you have to remember, CCTCIS. That is crime, corruption, tax evasion, court interference, immorality, and safety. Now, the effect of illegal contracts is that they are completely unenforceable. For void contracts, I want you to remember MOR, that is marriage interference, Austin court, and restraint of trade. So that the effect of void contracts is that they are generally unenforceable, but they can be served. Now, the golden rule is that you must always ask, is the object unlawful? That is it illegal? Is it against public policy? That is void or illegal? Is restraint, reasonable? That is, can it be enforced? Those are the questions you must ask, before entering into any contract. Now, if it is your first time here, make sure to subscribe and to follow this channel for more legal lessons. My name is Biketi, and see you in the next one.